Hello, class, and welcome to this week's lecture. This week's lecture is going to be on civil rights and how civil rights plays into the legal field. So, as we get started, I'm going to get right into with what is going to be the most tested part of civil rights inside of the law, and that's the Civil Rights Act of 1964. Now, just to give us a little bit of information about the Civil Rights Act and kind of the story behind it is, so the nation, obviously is founded, and there's a lot of discrimination towards people of, any different, whether it's race, color, religion, national origin, gender, disabilities, whatever. There's a huge amount of discrimination in the 1700s and 1800s, and we fight a war about it in the 1860s, and then there's a bunch of Supreme Court cases that kind of say, hey, separate but equal's okay. We're moving towards equality, but we're not there. Fast forward all the way to the 1960s, which really isn't that long ago, okay? 50, 60 years ago, there's the 1960s, and inside of that is this whole concept of we want to be equal, okay? So no more of this separate but equal, but physically equal. And the government decides to pass the Civil Rights Act of 1964. So what it does is this Civil Rights Act of 1964 establishes regulations in terms of discrimination based upon four areas or four types of people. You can't discriminate based upon race, upon color, upon religion, and upon national origin. Okay, so race, color, religion, national origin. Now you're going to want to know all four of those. You will see that on an exam. But you'll notice, and we'll talk about a little bit later, but you'll notice there's nothing in the Civil Rights Act of 1964 that protects against gender discrimination, people with disabilities and discrimination, nor does it speak to any type of discrimination based on sexual orientation. So 1964, though, keep in mind, there's a lot of race riots, and it's the hot button issue of the time. And so the Civil Rights Act of 1964 passes because it doesn't include anything other than these four. If it would have included sexual orientation, or gender rights, or something else, probably doesn't pass. Okay, so they got this passed, and it was a great act because it protected those four classifications of people. Now, one thing I do want to kind of, just make awareness to is that this act was a little different because it included all races, all colors, all religions, all national origins, and that was an important part of the bill because it didn't just say it's for African Americans or it's for people from Japan it said all, and that's why it passed. I mean, that was one of the things that got several senators to approve it, is because it didn't allow for reverse discrimination. So I will give you an example of later in the lecture of how the case went all the way to the state Supreme Court based upon a Caucasian couple being discriminated against a Korean restaurant. So we'll talk about that later. So that's the four people. Now, they also narrowed it in scope. Got to remember, this was not popular back in the 60s, the passing of this. There was a lot of racism. And they didn't say you can't discriminate anywhere. They said there's only four places that this law takes effect in. Okay? So you cannot discriminate in lodging, so anywhere where people would find shelter. Okay? You cannot discriminate in dining facilities, so anywhere you would eat. You cannot discriminate in any place of entertainment. Now that's a pretty wide scope, but theaters, sporting events, going to movies, I don't know, anything that's entertainment based, which is a very large gamut, a very large scope of area. And the final one, which sounds a little odd, but gas stations. So, lodging, dining, entertainment, gas stations. You'll want to know all four of those. It will be on an exam. Um, and kind of where it's at is you're like, well, that's interesting. Why those four? Well, it's because they were really trying to affect the hospitality industry first. That's where they were starting with. Because we have a fundamental right to travel in the United States, and it was really getting abridged. So people of race and color, they couldn't find a legitimate place to stay the night when they were traveling. They couldn't eat in restaurants, gas stations. This was a big deal. If you were on the interstate, you're a person of whatever religion, and you're in Jacksonville, and you are trying to travel to see your wedding of your niece in Washington, D.C., which means halfway between there, you got to get gas. And halfway between is South Carolina. There's a very good chance that none of the gas stations would service someone that was of a particular race, color, national origin, or religion. Like, you could potentially not be able to get to Washington, D.C. because of the gas situation, or you would have to do like a lot of people of color or religion or national origin of that time did, and it's too incredibly dangerous. But they would have to fill their trunks with gas containers. Okay, so they would have gas riding in the back of their trunk, and they would go that way, and of course the fumes are getting in the car. It's bad, but they needed gas, and they knew that when going through South Carolina, they wouldn't be able to get it. So in order to asphyxiate travel, gas stations were included. So now, why does the federal government get to make this law? I mean, what gives them the power inside of the law? Well, this goes back to our constitutional law lectures, where we talk about the commerce power. Okay, so the federal government has the right to regulate anything in interstate commerce. Huge word, gonna be on the exam. Interstate commerce. Interstate commerce is, I'm going to read the actual definition. Interstate commerce is business affecting more than one state, as opposed to business being done between two parties in the same state. Okay, this is a very broad concept. Almost everything's interstate commerce. So anything that you buy or travel to probably cross state lines at some point. So for instance, if you are currently watching this on your Apple laptop and you bought it in Florida, well, it wasn't made in Florida. Okay? Or one of its parts wasn't made in Florida. The screen is made in Washington, and the keyboard is made in Mexico, and the processor's made in Asia. I mean, parts come from different places. It makes it interstate commerce. Same thing when it comes to dining facilities. One of the big cases on point there was a restaurant, and they said that we only serve people in Alabama. I mean, we only advertise in Alabama. We're in the middle of the state. We're not off an interstate. We don't have any billboards directing people to us. We're just here in Alabama, federal government, so don't try and regulate us. However, their beef comes from Arkansas, I think, or their chicken, something like that, came from Arkansas, and they're like, well, the food you sell crosses state lines. The forks that you use are produced in California. The plates that you use, and so on and so forth. Even to the point where it's like the light bulbs in your ceiling are manufactured in wherever. So at the end of the day, pretty much everything is interstate commerce. There's very, very, very few examples of something that isn't interstate commerce. So you want to know interstate commerce, and that is any commerce that travels state lines. Intrastate commerce is where it's just inside the state. Okay, so those are the two types. Inter, crosses state lines. Intra, stays inside the state. So as we move forward, so the Civil Rights Act, basically says, hey, listen, these four places, you cannot, discriminate against anyone. But what happens if they do? I mean, so there's a gas station, and they refuse to sell gas to anyone who is of a certain religion, okay? Well, here's the things. You can sue them for two things, and you'll want to know both of these two. They're highly tested. A lot of times they'll ask you, what can you sue for, or what are the damages that can be obtained in a lawsuit revolving around the Civil Rights Act in 1964. There are two things you can ask for. The first thing you can ask for is injunctive relief. That means for the court to command them to begin to serve gas to a certain religion, and if they don't, well, then they would be in contempt of court and they go to jail and all those kinds of things. So injunctive relief, okay? And the second thing, which is incredibly important, is you're entitled to reasonable attorney's fees. So people say to us all the time, well, why is that a big deal? It's because the people that were, a lot of the people who were affected by discrimination didn't have the money to go hire an attorney. So you pull up to the gas station, they're like, no, we won't serve you because of whatever the reason is. A lot of times those people didn't have $10,000 to go retain a constitutional law attorney to fight for them, okay? So they passed this Attorney's Fees Act. So as an attorney, I'm sitting in my office and someone comes in and says, hey, listen, I was at the gas station, they have a great case, they have witnesses, they wouldn't be served, it's not just them, it's other people, blah, blah, blah. They don't need to pay me anything. I can take the case, and when I win it, the gas station has to pay me all of my fees, okay? And that's great. I mean, that's a great best case scenario for the discriminated party, because they get to go in there and get justice, I guess you could say, for their claim, and the attorney has the ability to make money as well, and the court has the ability to make sure that this place, because of the injunctive relief provision, to command them to do it, and if they don't, they go to jail. So it worked for everybody. So those are the two things, and I guess it's not the only things people could sue for, but it's the two that are that will be tested. Injunctive relief and reasonable attorney fees. You want to know both of those for sure. All right. So as the act goes on, an interesting question became: does it protect white Americans? Because white Americans really aren't a protected class. They don't need to be a protected class. They haven't been discriminated against anywhere near people of other races or other religions or other national origins or color. I mean, so everyone thought, well, this really isn't, does this include reverse discrimination, like people again that are discriminating against white people? And yes, it does. So the main case that goes to the Supreme Court is based upon it was a state Supreme Court, but still. It's based upon a family who goes into a Korean restaurant. They're a white family, and they come in and they're like, hey, we'd like to have lunch. And they say, you can't come in because you're not a member of our club. We're a private club. So we're about to talk about exemptions to the Civil Rights Act. So they're like, we're a private club. And as a private club, one of the factors, you got to be a member. So they leave, and they talking to somebody else, and they're like, yeah, we got turned down there as well. So they decide to all four go down there and check it out one more time, and they walk in there, and this time they have someone who's African American with them, and they get turned away again. But as they're leaving, a Korean couple comes in, and they physically say to the lady at the thing, the lady goes, what's your member number? And they go, we're not members, we're just coming to have dinner today. And they let them right in. And this, group of people who were denied entry were like, well, hold on, you said we couldn't come in because we're not members, but they just told you they're not members, and you let them right in. And then there was a little bit of an investigation, and yes, they were definitely, this Korean restaurant was only allowing Korean people in, and they were standing behind the private club exemption. So you can't do that, which we're going to talk about in a minute. But the overlying aspect of it is it included all people. And sometimes that's tested, okay? Does the Civil Rights Act cover people of all races? And it was a good question of law at the time, and the answer is yes. I mean, absolutely. There was a big case. It wasn't too long ago either. It was Airbnb. They had to change their policies. So what happens with these Airbnbs is, so I have an Airbnb, okay, that I rent out, and it is a condo on the beach, okay? And a African American family calls me, and I see their profile, look them up on Facebook, whatever it is, and I'm like, ooh, sorry, it's already rented. or they're a Muslim family, or they're a Christian family, whatever. It doesn't matter. And I say, nope, I'm not going to rent to you. Sorry. And I don't say I'm not going to rent to you. I say it's rented. Okay? I just hadn't taken it down yet. And they're like, oh, okay. So they go around the other way, and I just keep it up, and I'm waiting for the right family to come in that I want to rent to. Well, you can't do that. That is a major violation. So Airbnb adapted some new policies, inside of their company. And I want to read you kind of a synopsis of their policy now. So this is what they did to change that. It's because people were discriminating. And what it says is, new policy and procedures now require hosts to not discriminate on the basis of race, color, ethnicity, national origin, religion, sexual orientation, gender identity, or marital status. It allows a host to restrict rentals to people of the same gender as the host if, and only if, the host shares that living space. So, if I'm on Airbnb and I'm like, hey, I have a room for rent, and I am a female, and I only want to rent to another female, you can do that, okay? Which I know still doesn't sit right with me, but I get the reasoning. That'll change in the future. However, currently that's allowed. So if you share the space, additionally, the site now blocks hosts from relisting a space when they have told a potential guest that it's already booked. An additional modification is that guests will soon be able to use instant booking feature, which allows renters contract for space immediately without host approval. So they're putting policies in because it's happening in Airbnbs, and I don't know, it's all different, classes of people. So it's not following on the Civil Rights Act of 1964, so that's only 4 people. Okay, this is saying pretty much anybody you can't discriminate against if you're going to use an Airbnb, and that was a response to owners who were, effectively not allowing people of certain, sexual orientations, races, religions, or they're like, oh, you two are coming to a 1-bedroom place, and you're boyfriend girlfriend, and you're not married. We don't do that. I mean, you can't say that anymore. You can't say because of marital status, we're not going to allow it. So there's some exempt establishments from the Civil Rights Act of 1964. Okay, so these exempt places are pretty much the major one is private clubs. That's the one that you really got to know. There are some other maybe governmental agencies and things like that, but not really. It's really private clubs. That's like 99.9% is that. So let's talk about private clubs. So how do you determine if someone's actually a private club or they're just using that as a shield to protect them against Civil Rights Act of 1964? Because that happens quite often, where they just say, like that Korean restaurant did, we're private. Well, let's see if you're really private. And what the Supreme Court said is basically there are 6 factors that we're going to go over, and I'm actually going to read them to you. I don't like reading stuff to you guys out of books, but unfortunately, these are some of these are thought-provoking, so I'm going to go ahead and read them. The first one is the club selective in choosing its members? A private club usually has a limited number of members. The more selective the club is, the more likely it's qualify as a private club. So what does that mean? First factor we're looking at is how exclusive is it? Okay, so if I have a private club and we're going to call it Glenn's Club, and at Glenn's Club we only have 100 members. Okay, I'm actually part of a club. It's called the Osceola 100. Okay, and they have 100 members, and that's it. And it's very exclusive. So when you're in that is one factor. Now, it's not the only factor, but if you want to show me that you're a private club, it's not just open to anybody. It's open to a certain number of people. Okay, that's a good factor for you. The second one, are new members sought discreetly? If a club publicly advertises for member is likely not a public club. So if I have Glenn's Club and I'm running newspaper ads and things like that, and I'm like, please, I need members, come on in. That doesn't mean that it's not a private club, but that is a factor of if only you get in through word of mouth, things like that, it's more exclusive. The more exclusive the club, the more chance that it's actually private. For the court to say, yeah, you're private, you can discriminate. So these are the factors. So if someone were to come to me as a private club owner, they're like, hey, listen, I want to keep this certain style of people out of my club. What can I do? Well, you have to be private. And how am I private? Well, we start with this. You got to be exclusive. Limit the number of members you have. Say 100 members, 500 members, 1,000 members. I don't care what the number is, but there has to be a limit. Make a cutoff number. Second thing, don't advertise for it. Make it word of mouth. And distinctively say in your bylaws, we don't advertise for members. This is to be done discreetly. Okay? Discreet membership is factor 2. 3, does the club clearly have a design criteria for choosing members, and do the members participate in the selection process? A private club typically has specific traits it seeks to perpetrate its members. The more specific the criteria, the more likely the club will qualify. Also, by participating in the selection process, members help to ensure that the interests they share with the other members will continue to bind their membership in the future. Okay, so Glenn's club is the Italian American club, okay, because I'm Italian. And inside of this club, we only want Italian people, and we want to talk about our heritage. So we are asking for, in our bylaws, for only Italian Americans, and we have a membership committee of 10 people from our board, and they require you to take a, Ancestry.com Italian thing. You have to be a minimum of 25% Italian to get into our club. That's the kinds of things that make you private, okay? That's what you would say in your bylaws. Our members have the ability to vote you in. It takes at least one member sponsoring, and you must get an affirmative vote of 50% of the membership committee. They interview you. You have to do all these different steps, and this is what we are. You've clearly defined we're the Italian American Club, and we're looking for Italian Americans. So that would be the next thing. Clearly defined type of club you are, and once again, talking about members being involved. And why is that important? Because then it's not a business, it's a club, it's members. Everyone has a say, kind of thing. The court likes that. So that's the third one. The fourth one, do members govern and control the club's operation? A private club is usually owned and governed by its members. If the club is simply a business offer of profit, it will not qualify as a private club. So if Glenn's club, I run it, I make all the decisions, well, it's just like a business. That's not a club. When you form a club, it's like, I heard a judge once talk about it, he analyzed it as a tree house when you're a kid. So you're a kid, and you guys build a tree house, and you form the Girls Aren't Allowed Club, okay? And inside of this tree house, it's boys only, okay? And it's on someone's land, and it's, somebody helped build it, somebody started it, but they're not the boss of it. You have 5 members of your club, and they're all 5 boys in elementary school, and you guys are all collectively making decisions. That's a club. If the tree house, the Girls Aren't Allowed Club, and I built it, and I make all the decisions, and you guys are just there as almost like my employees because you have no say, that's not a club. That's a business. So that's the next factor. Factor 5. To what extent are club facilities available for use of non-member? The more access to non-member, the less likely you have a club. So if we have a club, Glenn's Club, and we're like, hey, non-members can come in and eat at our restaurant on Tuesdays. Okay, that's okay. You can still be a private club. Because what we're doing is it's a slow time, and we're trying to attract new members is what we're doing with the Tuesday, brunch openings for non-members. That's okay. But if you said, hey, listen, non-member come in anytime, they just pay more. You're probably not a private club then. That's not very private. I belong to an actual club like that. That you can go into. If you're a member, you pay one price. If you're a non-member, you pay another. That's not a private club. Okay, that's just a business. So that would be the 5th one. And the final one is the primary purpose of the club social or business. If the primary purpose is business, it's not a private club. It needs to have a social aspect to it. Like, we're the Italian Americans and we're promoting Italian heritage. That would be private. But if we're the Italian American Club and what we do is we sell spaghetti to raise money for ourselves, That would be a business. So private club, really what it comes down to is if you can meet these factors, you can tell someone, no, you can't join because of your race or national origin, because that's what the private club is about. But it's got to meet all these things, okay? And if it doesn't and they get sued, what are the two things they can sue for? Injunctive relief and attorney's fees. And that is what drives that style of case. So the next thing that we're going into is, obviously that doesn't, those four groups of people wasn't good enough. Okay, it just isn't at the end of the day, because there's other protected classes that need to be increased. And then probably the next biggest act comes in 1991. It's the American with Disabilities Act, the ADA. This is huge. This is one of the best pieces of legislation we've ever passed in our country. Okay, that was very much an opinion and not factual, but in my opinion, this is a tremendous win for our disabled citizens. So what the ADA says is, hey, if it's a public accommodation, okay, once again, back in that hospitality industry, okay, if it's a public accommodation, dining, lodging, things like that, entertainment, even businesses in general, you need to comply with ADA. And what is that? They need to have access. So if I'm a hotel, I need to have handicap rooms. Now, they may sell out. I may only have one. Whatever it is, but I need to have handicap rooms for handicapped people. Okay? And if I'm a business, okay, I need to have a ramp that people can get into my door. Okay? So say I own a restaurant. I need to have a ramp they can get into. I need to have a table in which they could wheel up to. I need to have a bathroom that's accessible to someone with ADA. That needs ADA compliance. Because at the end of the day, if they need to use the facilities, I have to provide that. That's part of doing business as a restaurant. So it was huge, and it's very alive today. You can't get a business license and do any type of new construction when the ADA is involved, and it always is. There is no time when it doesn't. Now, inside of the ADA is a whole discussion that we're not going to get into, but it's a thought-provoking discussion, and a lot of times I make it a discussion post, and it can be a little dicey, but service animals fall under ADA. So at what point, there's obviously certifications and everything else between companion animals and service animals and things like that, but what about in restaurants? What about in hotels? What if I'm allergic to dogs and I'm in a restaurant and you come in with your dog? A whole bunch of different stuff, and maybe I'll make a discussion post this semester. If I do, it'll be fun. But this falls under ADA. So wherever you stand on service animals, that's kind of where they get their ability to find legislation to allow them to have their animals. Now, kind of finishing it up for the civil rights portion is, so the Civil Rights Act really only encompasses those four people. So then what happens is states jump on board, and states begin to pass laws protecting sexual orientation and gender and age, all these different avenues, up into the point to where we get to 2015, and there's a huge case. It's the Obergefell case. It's the Supreme Court case that says that marriage is a fundamental right. Well, we already had that as a fundamental right, but it says that it's a fundamental right for all people, regardless of your sexual orientation. So it mandates that states cannot discriminate against, in a marriage concept, the status between two men or two women. And that particular case was huge because about the last, it's not the last, there's always be something else, but it's one of the last big areas of discrimination with sexual orientation. in our nation. In 2015, we ended it. Now, you're never in discrimination, but it really went a long way, the Oglesville case, in putting us on the right track. So kind of the timeline is it starts in, really it starts in the early 1900s with women's suffrage, allowing women to vote. And then in 1964, we get some civil rights stuff protecting mainly race and national origin and religion. 1991, big case, American Disability giving us disabled people access. And then finally in 2015, huge case, Oglesville, legitimizing the marriages of same-sex couples. So the law is ever changing, and as a nation we get more and more progressive as it goes along. And civil rights are very important inside of any business. It's huge inside the hospitality business because those are almost necessities in the world, but in business in general, so regardless if it's hospitality, so state statutes say, so like Florida has a statute that says, hey, no business can discriminate against someone of race. Okay, none. There is none. Now, unless you're a private club, there are exceptions. But so if I say I don't want to open up a hospitality line, industry line, I want to open up a hardware store, I cannot discriminate against someone. Okay, because now state statutes have come in and have come to a heightened level. Okay, so that's kind of the way it works. Is the federal law is always the top law. Okay, and states can make it more stringent, just not less stringent. So states could say, okay, so the federal government says race, national origin, color, and religion. Okay, well, a state could say we're adding sexual orientation to that. Okay. They can do that. They can add to it and make more protections. What they can't do is take away. So a state can't say, we don't know about that religion one. We good on race and color and national origin. We love everybody from everywhere, unless they pray to the wrong deity. They can't take one away. States can only add to them, and states add consistently to them through their statutes. And that's how we get all the protections we can and more businesses. But it all started with the Civil Rights Act 1964. So without further ado, thank you everybody for tuning in to this lecture, and we'll see you next time.